I want to talk to you a little bit about kind of some follow-up regarding Ewing versus Goldstein and the Northridge case. You all, I'm sure, remember it. It's a pretty disturbing case. And it was the rule of law that the Southern California Appellate Court decided and said that if a family member, in a later case they said immediate family member, informs the therapist that, or communicates to the therapist that our client or patient is a serious threat of physical harm or violence to an identifiable third party or parties, we then have a duty to warn. And that duty to warn is, as you all know, we make reasonable attempts to inform the intended victim, and we also contact the police. We call the police. After those two cases, there were a number of things that happened. First, Goldstein's attorneys attempted to appeal it to the Supreme Court of California. And the Supreme Court said, no, we're not interested. We're going to let this case stand. The California Association of Marriage and Family Therapists decided to push for an amendment for the statute that governs our behavior in this regard. That's 43.92 of the Civil Code. And Kampft had a very elegant solution. They found a representative, Joe Nation from, I think, Sonoma County, Sonoma and Marin counties, and he was willing to sponsor the bill. And essentially what they would do, what they were planning was to say, okay, we would like the law to say when a patient, him or herself, discloses to or communicates to the psychotherapist a serious threat of physical violence. Okay, so their fix was to simply make it very clear that it would be the patient, him or herself, and we changed 3 words in the statute. Well, that simple fix turned into a prolonged battle. For a variety of reasons, there was significant resistance at a legislative level to changing the law in that regard. And the amendment that was proposed was basically scuttled fairly quickly. A number of other amendments were proposed that were both minor and have no bearing really on overturning Ewing. They expand in a minor way some of the things we can do when we have a potentially violent patient. So it essentially implies that we can hospitalize, which we used to be able to do anyway, but it says we can hospitalize, that would be considered at least in part fulfilling the duty. But when push came to shove and a vote was taken and the governor signed off on it in August of 2006, Civil Code 43.92 basically has the identical language that it had prior to Kampft's attempt to change things. So we are in a situation, in my opinion, where the Ewing case is the current law in California, and that the statutory language minor modifications had no effect on that. Well, subsequent to the passage of the law in August, one of the attorneys for the California Association of Social Workers rendered a rather startling opinion that the statute changed the law and brought us back to pre-Ewing. In other words, the old rules about that it had to be the patient communicating to us. I have checked in a number of places and virtually no one else agrees. And I emailed and have had an exchange with the current president of the California Association of Social Workers, and we're in the process of having them reevaluate that assessment, because I think, plain and simple, it's just not it's not a knowledgeable interpretation of the law. And I certainly wouldn't feel comfortable telling my LCSW colleagues, oh, don't worry if you have a parent, as in the case of the Ewing versus Goldstein situation, who informs you that your client, their child, is threatening serious harm to a third party. I would be really loath to tell you, oh, don't worry about it. It's not a problem. It has to be the patient. I think the Ewing versus Goldstein and the Northridge hospital case, Ewing versus Northridge Hospital, have made it very clear, and the statute didn't change, not in a substantive way. So be aware that we may find ourselves in a situation where there's some difference of opinion about this, and for those of you online who are LCSWs, I would be really careful, and I would push for a reevaluation by CASW of their interpretation of the current law. Okay. The Ewing versus Goldstein case, the whole idea of what constitutes a family member, that's been a vexing kind of concern for many folks. For example, what happens if we get a call from an immediate family member, a parent of a client we're seeing, but this parent has not had contact with our client for 15 years. They essentially disowned the client, right? And they know them at this point not at all, but the person is an immediate family member. Well, we probably should use as our best guide that when a client determines or believes that a person is a family member, that's what we will use as a basis. That's true, and we need to be cautious. So if we get a call from an immediate family member and we think they're reliable, even if the client's really angry at them and is saying they're not any family member of mine, we also have to use our judgment. So to continue with the example of the very distant relative calling and are not being sure whether they're at all involved or reliable, then first checking with the client if we can do so, and then if we have pretty good information that this person is not a part of the client's life, we'll document why we think they're not a reliable reporter. So there are, almost, wouldn't quite say, thousands, but there are certainly hundreds of potential scenarios. And we could have a person who is not an immediate family member, but at least legally speaking, but who the client considers to be a family member. And that person may be a longtime partner. They may be a live-in partner, or they may be somebody who has been very close and intimate and has provided us with good, reliable information in the past. In that case, we'd probably be in good, in a good position to say, okay, we're going to rely on this information. The fact is, though, that we're just interpreting what the court has said, and the court is not very clear. So this is a somewhat risky situation, and very, very important, as I have said, and as you heard in my presentation, gotta consult with other professionals given a particular scenario, okay? What about a very good friend? The person may know more than a family member. Yes, that's true. This is the place where we're stuck with the court's language. In Ewing, the court said a family member. In Northridge, they interpreted what they previously said as, well, an immediate family member, but they didn't define either. And they didn't say a very good friend. So if we use the perspective that a person who's considered by a client to be a family member, somebody they're living with, for example, I think that that will be a reasonably good judgment. But when it's a very good friend, we are, to use a saying by an old law school professor of mine, we are up a tree without a paddle, because we do not really know whether a court's going to support us or not. In that situation, I'd be inclined to try to get the person hospitalized, to do, and definitely to talk, that is the client, and definitely to try to talk to the client first to see if I could get myself out from under having to make that judgment about, is this person potentially considered a family member, or will a court decide they're not, and I've breached this client's confidentiality, okay? So that's a tough one, and there may not be an elegant answer to that particular issue. Another question related to this concern is, if this is an estranged family member, I thought we were expected to protect the client's confidentiality and not even divulge that we are seeing the client. Actually, that's true when anyone calls us, okay? whether it's a close family member or not, we don't even acknowledge that the client is somebody we are seeing. But consider the following scenario. You pick up your messages, and you pick up your messages on your voicemail, and lo and behold, there's somebody saying, my name is Robert Lee, and I'm the parent of your client, Jane Lee, and I think she's going to kill her landlord. Okay, so we're not saying to anyone, we're seeing this client. This is somebody who's contacting us and giving information. Okay, so we are expected to protect the client's confidentiality. We can't even divulge that we're seeing them, but we can listen, and we often will be in the position of listening, even when we don't want to. Okay, so that creates some, in this circumstance, creates some complexity and some difficulty for us. If we receive a message, the question is, should we talk to the client first before we contact the potential victim? If we can do that first, absolutely. Because what happens there is we get the opportunity to evaluate whether we believe that the report is reliable and whether we think that this client is potentially dangerous to a third party. So to go back to the Ewing case as an example, one of the things that Dr. Goldstein might have done, and this is Monday morning quarterbacking, is when he got the phone call from Gino's dad, is to say to his dad, put Gino on the phone, and then have a conversation with Gino. The interesting result of that phone conversation would have been that this case would not have happened. I don't mean to say that Dr. Goldstein would have prevented the harm. The harm may have occurred, but we would not have had a court ruling that a parent's or an immediate family member's disclosure to the therapist is sufficient to trigger Tarasoff, because Goldstein would have been making the judgment on the basis of what Gino said, not what the father said. That puts us in a stronger position in deciding to make or not make a Tarasoff report. Okay, so absolutely a great idea to talk to the client first. And in fact, whether we receive a message, whether we actually talk to a family member in person, we have I think it's a really important step to take. Step number one, talk to the client if it's at all possible. And if it's an urgent situation, then we can't reach the client, then we have to make a judgment. Okay?